Good morning, everybody, and welcome to the fourth in this series of IMAP MDA 360 webinars. We've covered conflicts of interest, fiduciary duties, PI insurance, and today we're going to cover another relatively technical area in the way MDAs are operated and advised on. I'm delighted today to be joined by Michael Mavromatis, partner of Holley Nethercote, to talk to us about fee disclosure for MDAs. Before I hand over to Michael, just a few words about the rest of the MDA 360 program. Tomorrow we'll be broadening the focus to a more managed account-centric view. And we'll be talking with Mark Watmore from NMG Consulting about the strategic challenges that operating a managed account program gives rise to for advisors and the strategic opportunities as well. In October, we'll be hosting the first of our masterclasses on best practice advice for MDAs. We'll have Simon Carradis from Hamilton Locke, James Zoe from Cambo, and Luke Brixton from First Financial talking about the process for giving advice around MDAs. It's a full-day session here in Sydney with a workbook, and I'd encourage you, if this is part of your advice process or if you are an MDA provider relying on external MDA advisors to attend this masterclass. The 18th of November, we'll have a masterclass on responsible manager obligations. That's the day before our MDA leadership summit. As you'll all know, I'm sure, ASIC will be releasing the MDA instrument in September to go live on the 1st of October, they say. And the masterclass and, more importantly, the Leadership Summit will be there to essentially draw together MDA practitioners to understand what the changes, if any, to the instrument mean. Does this mean now just 10 more years carry on as we were, or more likely the changes that ASIC has proposed or implemented and the impact of that on the advice and MDA operation process? And then in December, we'll be running a masterclass on establishing a risk management framework for MDAs. So it's a full program for the second half of this year, focused on operating better, more efficient, more compliant MDA programs for advice. We'll repeat many of the elements of the MDA 360 program in 2027, but I'd encourage you to participate in these three masterclasses, sharing the attendance amongst your colleagues so that those for whom it's most appropriate attend. As you'll see, the participants in the MDA 360 program, as today with Michael, are generally partners from leading legal firms specializing in this area, or consultants or brokers with specialist knowledge in this area. This program is made possible by the support of Mason Stevens as the principal sponsor for the MDA 360 program. And in a moment, I'll invite Nick to say a few words. But before I do, let me just remind you that in September, we'll also be hosting an afternoon session at the Fullerton as part of Sydney Alternatives Week on alternatives and discretionary portfolio management. Alternatives are increasingly part of the advice process, and MDAs are an ideal way to integrate alternative investments into properly managed portfolios. Today, as I say, will be relatively technical, and I'd encourage you to ask a question as we go through the button, of course, at the bottom. So now, look, it's my pleasure to introduce Nick Mitchell. Nick, thanks very much for your support for this program.
Thank you, Toby, and g'day everyone who is attending today's session. We're very proud here at Mason Stevens to partner with IMAP for this series, amongst other things. And what we're trying to do collectively is demystify the finer points of establishing and managing and advising clients under an MDA service. For those of you who aren't familiar, at Mason Stevens, we're a platform that has been at the forefront of MDAs for over 16 years now. We're the only wealth platform in Australia with an integrated MDA offering. And we think we understand what it takes to deliver a pretty exceptional managed account experience, not only at the portfolio manager level, but also right through to the end client. And that experience runs very deep. The majority of funds that actually sit on our platform are operated under an MDA. And that really drives how we develop our service proposition as a platform and all of the technology that goes with it. And, obviously that's dedicated to ensuring that it works well and seamlessly for partners and clients. We are a team of investments and markets people, so we understand what it takes to deliver proper investment outcomes, whether that's utilising our live trading desk, assisting with governance, investment committee frameworks, providing investment committee representation, or delivering analytics and reporting. We've got a very broad suite of services that enables our partners to deliver better portfolio outcomes for their clients, particularly in that wholesale and high net worth space. But that's enough from me. I'm looking forward to hearing from Michael today. And as always, reach out, please, if you'd like to chat about how we can assist. But for now, I'll throw it back to Toby. Enjoy the session.
Thanks, Nick. Michael, welcome to this session. And I'm looking forward to the presentation on fee disclosure. Who would have thought I'd say that?
Thanks, Toby. And you did say it's a technical session, but for the sake of the attendees today, let's try and keep it light and conversational. See how we go. So I'll now share my slide deck. Let me know when that comes up.
Yep, good.
We got full screen there.
Not yet. No.
Almost there. That should have done it.
Yep.
Right. Thanks, Toby and Nick. Let's get started. We are talking about MDA fee disclosure today and a number of other topics as well. So where do we start? Okay. So you're all probably aware of RG97. I would hope so anyway. Why is it so complicated when it comes to MDAs? Well, firstly, RG97 is complicated without even involving MDAs, and we'll get into that a bit later. Some of the examples we'll go through should be helpful, but they will be relatively high level because, as I always say, no two MDAs are the same, and you really need to have a good look at your own models for that purpose. We're also going to have a look at retail versus wholesale client classification. That is a hot topic at the moment, given that there's been some regulatory action in that space. We're actually going to skip over conflicts. That's been covered quite comprehensively in another session. And we might finish off discussing the topic of what makes someone independent. Can you use that word? And well, it's a restricted word. So what measures would you put in place to use that word when describing your financial services business, and would you want to? All right, so let's start by looking at RG97, which is where you will find relevant guidance as to how to share fee disclosure. So forget about MDAs for the minute. Let's just talk about the journey when it comes to RG97. Think back to 2004. There was an ASIC FAQ that was around for years. It was actually quite helpful. In 2011, that was replaced by an initial version of RG97. In 2014, there was a class order setting out how ASIC expected fee disclosure to be provided. That was followed in 2015 by the rewrite of RG97. fast forward to 2017, there was a transitional RG97, which I'm sure you'll remember as well. There was an industry working group. ASIC decided, rightly so, that there was, a lot more clarity needed when it came to RG97. An industry expert was appointed to conduct a review. There was a new version of RG97, which was a transitional version. Then COVID happened. Then the final version of RG97 was handed down. So that's quite a journey. And how do MDAs fit into the mix? And Toby, you'll probably say not well, but I don't want to put words into your mouth. So where do MDAs fit into the mix? So when you think about fee disclosure and you think about managed investments and super, as you do when it comes to RG97, ASIC's view is, yes, this is the disclosure that go through a number of steps in relation to how fee disclosure is to apply to managed investment schemes. And then at the end of that, what ASIC says in RG179, which is the regulatory guide on MDAs, the MDA contract must contain information about the fees and costs of the MDA in a manner that is consistent with Schedule 10 of the Corps Regs, as if it were a PDS for a registered scheme. As if it were. So that's not easy. Now, if you dig down into the detail, an MDA technically meets the requirements of a managed investment scheme. That doesn't make it a registered scheme. It's a very different beast. Issuers rely on the relevant ASIC instrument for that purpose. Now, disclosure is so complicated when it comes to RG97 that then suddenly saying, well, essentially pretend that this is a managed investment scheme makes things difficult. All right, so we might even talk about some of the key issues when it comes to fee disclosure and RG97. Now, Toby, you did mention where do interposed vehicles fit into all of this. It's a very good question. Depends on the structure of your MDA. This comes up all the time. So you need to know whether a particular investment in the chain is an interposed vehicle so that you can work out whether indirect costs associated with that vehicle need to be counted towards the final management cost for your relevant MDA. Now, what is an interposed vehicle? So we've just provided you a brief description. In a very, very informal sense, think of it almost like a fund of funds inside another managed investment scheme that's been invested into. That's the starting point before you even talk about MDAs. So when you look at RG97, if things aren't complicated enough, the definition of what an interposed vehicle is, it's provided, and then ASIC sets out 10 pages of commentary on what an interposed vehicle is, including 6 pages of flowcharts. And that's even before you get to the idea that an MDA might be involved. So that's not the best position to be in, but happy to work through an example probably at this stage, Toby.
Yep.
All right. So what we've got here, rather than choosing an MDA provider randomly out of the industry and sharing their fee disclosure, which would be a terrible thing to do, I've actually shared Holley Nethercote's FSG MDA template here. I'll provide details on how to get that later if you would like to. But I thought we might use this for the purposes of a fee disclosure example. So that's what the front of our policies usually look like. Now, the wording that I've extracted, so this wording is exactly the same, and this has come from the regulations because you literally do need to use that table when it comes to fee disclosure. Some of the other examples that I've used, I've changed slightly for the purposes of this presentation. They're not exactly how you'll find them in our template, but it will just work better that way, trust me. So when you look at a competitor's fee disclosure and they're an MDA provider and you find their FSG online potentially, there's a lot of different ways of doing this. There's only very few correct ways of providing fee disclosure when it comes to MDAs. So when you look at a competitor's MDA FSG and they don't have essentially the did you know table, you would think to yourself, how are they meeting the rest of the fee disclosure requirements, which we'll go through. Definitely do make sure that you include that. It's hard to miss when you go through the requirements. All right, there's just a disclaimer from HN in our documents. We're just having a light discussion today. We're not actually providing legal advice. It'd be hard to do anyway, again, because no two MDAs are the same. But enough about that disclaimer. Okay, this is a sample of part of a fee table from our HN Hub template on FSGs and fee disclosure. So we've got that did you know template at the top there. All right, before I get started, this isn't a disclaimer, but this is really, so look, we've talked about the journey on RG97 and fee disclosure and MDAs, and then the fact remains that the fee disclosure in RG97 really doesn't take MDAs into consideration at all, and then everyone's MDA is a little bit different. So when it comes to MDA fee disclosure, I would say it's treacherous. It's hard to get right. It's really hard. So whatever you see here today, I hope you use it as a useful high-level guide. But I would suggest that you do get legal advice from a lawyer in this area when next revising your MDA, FSG, and associated documentation. It's highly prescriptive. It's hard to get right because RG97 doesn't really contemplate how MDAs operate. The other thing is when you look at this table, so this is just our template, we talk about management fees and costs here. Now that's a combination of the costs of the MDA, and then ultimately you drill down and there's indirect costs related to various options inside that structure. When you look at the plain and simple managed investment scheme fees and cost template that you're required to use, forgetting about MDAs, pretending you're a managed investment scheme, it really is this straightforward and you're not expected to stray from those details. Now, many providers have gone to some lengths to try and make it clearer, I guess at their own risk because it's not the prescribed disclosure, but you are working something that isn't really fit for MDA. So you do see a bit of variation there. So for example, there's no number that says the ICR equals. Ultimately, all of those details need to factor up into that final management fees and costs. Now, there are different ways of doing it. So work with your own lawyers and work out what you're comfortable with. But in principle, this is how the table would look. The final fee figure would sit up here. You would then have the indirect cost. This wording I've got here, hopefully you can see the hand pointing at the yellow highlighting. That's not exactly the wording in our policy. I've changed it a bit for the purposes of this presentation because this is where it gets complicated. Now, when we were talking about interposed vehicles before, if something is an interposed vehicle, you do need to count those indirect costs towards the final management fees and cost calculation up here. But depending on whether something's technically an interposed vehicle or not, really depends on the type of model you're running, and then ultimately thinking about what would ASIC expect to see in that documentation. So there's many different kinds of MDAs as we've just discussed. There's MDAs that involve regulated platforms. They're certainly popular. There are MDAs that use their own custody. They don't necessarily rely on an external platform. Their disclosure might technically be a bit different. So it's hard to find a level playing field and something that's fair when it comes to fee disclosure. As an example, if you consider an ETF, for example, so forget about MDAs, just an ETF itself. That's literally the vehicle that would have the management fee component. But if it sat on a platform, as a starting point, you would say that's an interposed vehicle because you're investing in the platform. However, there's the platform rule when it comes to interposed vehicles, which is that the platform itself technically shouldn't count towards the costs of that. It doesn't end there though, because then ASIC says if it is an MDA, then the platform is an interposed vehicle when you have a look at RG179. So it's very circular. Do spend some time trying to get that right. Now, at the end of the day, if you have the fees associated with that ETF, whether you technically consider that to be an interposed vehicle or not, is a separate question. Ultimately, it doesn't matter too much because those amounts gradually would filter their way up to the ultimate management fees and cost calculation. Now, it is unfair because if you look at an IDPS and interposed vehicles, they can rely on the platform rule typically because that literally is the platform, but the MDA sits one level above that. Toby, is this getting too technical too soon?
No. Off you go. You're
All right. So that's what we're dealing with there.
so just
Yeah.
before we leave that
Yeah.
point, Michael.
Mhm.
So MDAs run on regulated platforms, could be run on IDPS or super platforms.
Yeah.
Uh, should the super wrap or the IDPS be treated in the same way, whichever way you think is appropriate to treat
Yes, think of them just before when I was discussing the underlying funds when it comes to an IDPS. I should have said more generically wrap, being a super wrap or an IDPS. It's the same section of the Corps Act that deals with those sort of vehicles where there's an element of custody provided within them. So we were just thinking about interposed vehicles from an MDA perspective. The other things you have to think about are when it comes to that definition, there's the assets test. So if a fund is being held by another fund and 70% of the assets are invested in securities or other financial products, but it's not at the top level, that's an interposed vehicle. It's actually hard to have a fund that doesn't have at least 70% of its assets invested in those sort of things anyway. So once there is a fund in a fund, that's when things get tricky. After that, there's the PDS test, which takes up a lot of that 10 pages of commentary and flowcharts I referred to before. I won't go through that now, but where the fund is the means of getting access to the underlying investments, that generally is the PDS test, but I would encourage you to go through that in your own time. However, depending on the type of MDA that you're running, you may not have to go into that level of detail. If in doubt, you would disclose a particular amount there. So this is only the top of the fees and costs table. I'm sure you've all seen the rest of the table. There's a contribution fee, potentially there's an exit fee. I mean, most of those are zero these days anyway, but you should include that information and you must. It's just not on this page for convenience purposes. That takes us to, there's a fee example that you then need to go through. There's some prescribed amounts there. Ultimately, in this table, you would have to include the costs of the underlying funds as well. When you look at those IDPS providers that I've referred to earlier, even though technically they might not need to carry that underlying fund amount up through to the ultimate management costs of the offer, when it comes to the fees and cost table, that ultimately is something that would be included. It is difficult to escape. When you get to MDAs, there's half a dozen, dozens of different potential portfolio models. That makes things complicated. One of the ways as though you might deal with that is have a final calculation for each of the portfolios potentially. A range makes it difficult unless you're going with the most expensive option, and that's, I mean, being unfair to the rest of the portfolios as well. So I won't say it's to choose your own adventure. It just requires careful thought and consideration and just ensuring that you're not misleading your audience, which is your investors. Any questions or comments on that, Toby?
No, just do you want to talk briefly about transaction costs? I mean, clearly brokerage would be a transaction cost.
Yes.
Would buy-sell spreads for managed funds be a transaction cost?
Yes, because that's a fee that you don't pay for personally, that would make its way up through the cost as opposed to brokerage. So if you had a particular model that was holding securities directly, I have seen it. I have seen different providers, different reputable providers do this in different ways. So that's a good question.
And so to summarize in this example page, because it sort of flows from the previous harder to read table, management fees is going to be the portfolio management fees that you charge. It may include platform costs if they are if they're an interposed vehicle, and it would typically include the ICRs of a representative portfolio. Performance fees, if you charge them, go in here, and then transaction costs, as we've just discussed, brokerage or or buy-sell spreads.
Yes, exactly. Completely agree with all of that. If you look at that table, there's the final, I'll say much maligned $50,000 example, which has existed forever. The problem with the example is that it assumes a constant balance, even though you're adding money during the year. There are some footnotes that you should include about that. It just got cut off here for convenience purposes and this page, but that is generally the table that you would use, and make sure you're as accurate as possible. And what Toby said, I thought that was a very clear description of how this table actually works. Now, there is an opportunity there to list different final amounts for different portfolios, which I would encourage. But yeah, get your own professional.
Well, I think it's worth drilling down a little into this issue of different amounts, because one of the things about MDA programs, but managed account programs generally, is there's a range of models, and the FSG is a generic document, struck at a point in time. So, do you want to talk a little about the issues that arise when the MDA program will run from conservative to high growth, and clearly, even if they have the same portfolio management fee, they might have very different underlying costs of investment.
Very true. And this is when it becomes just an example of when it becomes apparent how not fit for purpose this regime is when it comes to MDAs. What you would do, what I've seen done, is list different final total cost amounts for each portfolio to give your clients and potential clients an idea of what the cost of that portfolio might be. So if it's high growth, you would probably expect it to have a larger component of various costs in there, I would imagine. So that's one of the ways of doing it.
Now, the couple of questions have come up about this. So if multiple managed funds each have fees, but the weighting will change over time, can change over time, how do you avoid having ranges? And I guess by extension to that question, do those ranges bind you? So if you said, look, the reasonable uppermost range of our underlying investments is 1%, does that mean that having disclosed that in your FSG, you cannot go to a weighted average underlying ICR greater than 1%?
So, good question. Typically, the direct costs are real time, but we can talk about that. The indirect costs, you don't know until the end of the year anyway, and they happen retrospectively, and you'd be republishing those anyway to an extent. That's how you would do it with managed investments or super. So in a sense, they would be provided retrospectively. So I don't think that should be a problem. That's how I would see that working. Now, if you
so just to recap, so if you put in your reasonable estimate of the sort of the upper range of the costs, because nobody cares about being cheaper, the ICRs might range from 0.5 to 1, say. Does that upper limit bind you to not going above it if you disclose that in your FSG?
On direct costs, I would say yes, you would want to fix that. On indirect costs, that would ultimately wash out at the end of the year with historical data, and you'd have to replace it.
Right.
Anyway, that's what you'll do for a managed investment scheme. I'll see the same principle applying here, even though it is messier.
Right.
Hmm.
So what I take from that is you have to be able to demonstrate that you took reasonable efforts in arriving at something which was not misleading. I mean, you're running up against the misleading and deceptive issue, not the.
Yeah, you are, and I think it's a really good point, Toby. And I see these documents as being similar to PDSs. They're disclosure documents. So for the time being, even though you're an advice licensee, think about yourself as a fund manager. Think about yourself as the perpetuals of the world. They've got PDSs. They've got, at the big end of town, they would have a committee that verifies every sentence in the PDS. There's been a recent federal court case in relation to Vanguard where the court was critical of Vanguard. In that instance, what the court found was that their PDS verification process could have been more robust. So this is really no different. This is a serious disclosure document. So pretend you're a fund manager when you're signing off on these FSGs. And even more so, because if you're a fund manager, the FSG is a relatively straightforward document. This is where literally you've got fee disclosure as though it were a PDS. So I would spend a lot of time and a lot of effort, and it's not interesting to have to sit there with your relevant stakeholders and committee and verify each of the sentences in the fee disclosure table, but I certainly would be doing that.
A couple of other questions that have come through. What was the answer? Read the buy sell spread. Does that end up in the transaction costs?
That if it's an interposed vehicle, yes, it would.
Yep.
Yep.
But if you were just investing directly, if one of the investments was, for example, Fund X, Global Bond Fund, and it's got a buy-sell spread of 15 basis points, you would put in an estimate of the trend of the buy-sell spreads incurred through the.
Actually, the buy-sell spread won't be incurred though. So if you mean in an underlying fund, that's something that the underlying fund manager would apply to other investors, if that's the question.
Well, it was so if I'm running a managed account portfolio and it's got 10 managed funds in it, those managed bond fund, equity fund might be, for example, Pengana have got a fund of funds which is sometimes used in these private credit fund used in MDA portfolios. So if you're investing in Ausbil Australian Equities Fund and it's got a buy-sell spread of 20 basis points, but the underlyings in there are ASX stocks, would you think that the buy-sell spread there is to go into the transaction costs?
If it's an interposed vehicle, yes, but not if it's not being incurred. If you're just holding those units for a year, there wouldn't be a buy-sell spread because that's literally just applied to the investor who's transacting.
Yeah, but the MDA investor is that investor
who is transacting.
Who's having transactions incurred on their behalf. Yeah.
If that transaction is incurred on their behalf, and it's an interposed vehicle, I would be including it.
Yep.
I have seen it done differently by different providers though. So there might be some arguments there, but based on your question off the top of my head, I would have thought it is included because it is a cost associated with the interposed vehicle.
Yep. Okay. Another, as the management fees and costs include portfolio management fees, it means the individual costs for the portfolio management fee will not be disclosed. Is this correct?
I don't understand that one.
Yeah, I don't think that's right.
Yeah, I didn't understand the question.
So as the management fee, so whoever put this in, because it's from that prolific commentator, anonymous, um, uh, as the management fees and costs include portfolio management fees and MERs, it means the individual costs for the portfolio management fee and MER will not be disclosed. I guess that means, what I take that to mean, and I welcome a bit of clarity from who put it in. I take it that means that you will not, in your statement of advice, for example, need to disclose, you know, manager A, global equity fund, 20 basis point, 70 basis points, manager B, small cap global fund, MER 120 basis points or whatever it might be, because you've disclosed the aggregate weighted, expected weighted average ICR. We might get later on to some of the differences between
right.
SOAs and FSGs.
That's right for the FSG, because it would filter its way up. But you want to look very carefully at your precise structure before making a decision on that.
Okay.
We'd need some time to work that out as well.
Yep. Let's move on. Sorry.
Let's move on. So just quickly, versions of the document that you've seen small excerpts from just then is available on our HN Hub. There's a link. That link won't work in the video, but feel free to reach out. Happy to give anyone a tour of the hub as well. It's our subscription compliance related service. So yeah, feel free to reach out about that. All right. I keep saying no two MDA models are the same. It is a broad church. Now we've talked about MDAs that use regulated platforms. You've got MDA providers that insource most of the services, including administration and custody and so forth. On the other end of the spectrum, you've got OTC derivatives issuers and signal trading. That doesn't really apply so much to this group. You've got the robo-advice crowd. No doubt that will become more of an AI focus in future, but they're all MDAs. Now, if you're picking up someone else's disclosure and you think, okay, well, I can disclose whatever I'm doing in a particular way, it is difficult if your model doesn't function in exactly the same way. One of the examples of those things is internal versus external advisors and what that actually means. To have an external MDA advisor, it's actually a really technical set of circumstances based on the ASIC instrument that you need to satisfy. That external advisor needs to contract directly with the end clients. Sometimes we see internal advisors that look external because they're not the MDA provider, but they're not contracting with those other parties. Same issue with custodians. Some MDA providers will say that their custodian's external, and yet they don't have any one-on-one contracts between those end clients and the custodian. So it's always a good idea to do an annual review of what's happening with your office. Sometimes people have product creep. Their product and its disclosure is entirely correct on day one. They change a few small things, change a few more small things, and then suddenly the disclosure isn't right anymore. So it's really important to get that sort of thing right clearly. Toby, a couple of weeks ago, we were discussing wholesale models and why this is an area of interest. So from a regulatory perspective, it's been a big year in terms of ASIC pursuing licensees who it says haven't classified wholesale clients correctly. That's relevant to MDAs because now you do have wholesale MDAs, but sometimes, so you've got issuers who are very conscious about offering those, and other times you've got portfolio managers out there who start making these offers available. They don't realize they're notionally offering a wholesale MDA. So it's important to be on top of those sort of differences to make sure you're not doing that unintentionally. But back to wholesale enforcement from ASIC in terms of some of these licensees. So quite recently, ASIC imposed some license conditions on Corpay. So they're a corporate FX provider. ASIC alleged that they misclassified more than or almost 3,000 retail clients as wholesale. It was alleged they did not promptly remediate the clients. They didn't manage conflicts of interest. The biggest claim there was in terms of that incorrect retail client classification. Ultimately, what ASIC required was additional license conditions, including preparing a comprehensive remediation plan and then appointing an independent expert to make sure that that remediation plan has been correctly applied to each of those clients. So when ASIC talks about remediation, that would relate to those clients who were classified as wholesale and shouldn't have been classified as retail. So that can be, that's quite a significant issue. The other big one this year is Binance with their derivatives offer. ASIC ultimately cancelled their license, but also ran federal court proceedings. It's interesting because the court was actually looking for proof that the clients were wholesale, which goes a bit further than what a lot of providers have historically done. Now, given the nature of the wholesale tests, they're all very different. Some of those tests require less proof than others, but certainly a point worth mentioning. Things like sophisticated investors, your 761 GA test, making sure that you've met all the procedural steps. So, for example, assessing the client and then notifying and communicating to the client why they meet that test and why you believe they meet that test as well. It was alleged that Binance was only checking for knowledge and not experience. It's a hard one though, because ASIC hasn't really in the last 20 years or so or ever provided any prescriptive guidance on what sufficient experience would constitute. But we do have this decision now. Ultimately, Binance faced $10 million in penalties and $13 million in compensation for misclassifying retail clients as wholesale. So, yeah, we can see a trend there in terms of regulatory action, Toby. Right, just quickly, we also did talk about the emerging difference in views between what a wholesale client is between ASIC and AFCA. So historically, shouldn't say historically, the law says, forgetting about ASIC and AFCA, if you just look at the law says an SMSF client is required to have at least $10 million in assets to be treated as wholesale. That's a very high figure. In about 2014, ASIC released an FAQ saying they could see why you might assess an SMSF against the regular wholesale client tests. It then followed up with a no action position years after that, saying that the no action position is to the extent someone's properly relying on the general wholesale client tests, that the $10 million ultimately wouldn't be necessary. However, ASIC did say that's their interpretation and it wouldn't stop third-party actions or any other party deciding that they would suggest the Corporations Act applies in a different way. At the moment, that other party is AFCA. So two recent AFCA determinations had a look at this question and insisted on going back to the legislative test, which is essentially ensuring that those clients had $10 million in assets. So at the moment, the only safe, risk-free way of dealing with that issue is to ensure that your SMSF clients have $10 million, even though there's a no action position from ASIC, which is a slightly odd place to be. But this is where we are on that point.
With the wholesale retail test, I think what you say echoes what Jesse Vermilio said yesterday, I think, and Andrew Bradley on Tuesday.
That's good. That's
10
good.
million, yeah, exactly. Yes, 10 million. You know, SMSFs should have 10 million to be wholesale, i.e., almost none of them are. But what happens when you're dealing with where the investing vehicle is a company or a trust? And so again, same sort of thing. The company directors or the trustees of the trust might themselves personally qualify as wholesale.
Yes, it does.
Can they transfer that to the company or the trust?
Not a matter of transferring, it's a question of who controls the trust, and that person needs to meet that requirement. But before anyone just goes off and relies on those sort of interpretations, have a very careful look at what you're doing, in that you've just seen what can happen in terms of those finance and corporate decisions. So it's a really serious question, but ultimately, yes, it's the entity controlling the trust that needs to demonstrate that wholesale ability. Yep. All right.
Great. We've had some, I would remind everybody that's listening, we've had some great questions. So if you have other questions that are related to this, just fire them through the Q&A.
Thanks, Toby. And we talked about internal versus external custody or asset holding, if you want to call it that, a bit earlier. But always do have a careful look at your offer and make sure that you're expressing that correctly. That can also have an effect on your financial requirements when it comes to NTA and other financial requirements under your license as well. And yeah, you need to be quite clear and aware of exactly how you're providing those services. All right, now we did say we'd probably skip over conflicts of interest. Given that we've had a whole separate session on that. Probably the one thing I would say though is RG181 is relatively new after 20 years of having the same version. It now refers to conflicted REM examples in there as well. It includes some MDA examples in the schedule at the back as well. When it comes to structuring these sort of offers, we talked before about external advisors and what that can mean for fee disclosure. There can be some advantages there, but you need to be very careful to not inadvertently restructure your offer so that you're tripping up or tripping over unintentionally conflicted remuneration laws, even though your model might look exactly the same ultimately as it might otherwise have looked. All right. And Toby, you did say you wanted to have a brief chat about the term independence as well.
Yeah.
All right. So, basically, as you would all know, there's a number of restricted terms, let's say, in the Corporations Act that as a starting point, the safest thing is just not to use them. So, for example, the term independence. If you are desperate to use that to describe your
You're just breaking up a little, Michael, at least.
a whole number of hoops to jump in, not
Sorry, you're just breaking up there a little, Michael.
Yeah, in my case,
Right. Yeah. So,
is it still dropping out?
no, that's better. Yep.
Okay. All right. So, as I was saying, there are a whole number of hoops to jump through in terms of ensuring you're not accepting certain benefits. There are no restrictions placed on the sort of advice that you can provide by any third party. Ultimately, if you can do all of those things, you can call yourself independent. I would question why it is that important for your business. Maybe it is really important. You'd have to work through those hoops. you would then have to constantly ensure that nothing has changed in your business model that might mean that inadvertently you are no longer independent on paper or otherwise. So theory versus practice. So can you still hear me, Toby?
Yes, yeah, that's fine. Thanks,
Okay.
Michael. So the thing which gave rise to the questions about independence um, was a couple of MDA providers who spoke to me about either their use or their right to use, their current
Yeah.
use or their right to use the word independent,
Hmm.
in the context of the services they provide are, advice, typical, personal financial advice,
Yep.
and providing an MDA service for which they charge a portfolio management fee. So in both of the two instances that I'm thinking of, neither of them take any share of any downstream revenue. So no payments from fund managers, no payments from the platforms, although they collect their fees through the platforms. No share of brokerage, so no downstream payments. But as an advisor, they provide advice and they provide a portfolio management service through an MDA on the same license for which they charge a fee. So,
Yeah, that's a really good question. You'd want to have a look at that very carefully, but I think the one limit of the definition where it might start to cause issues is where there's any form of a restriction on the nature of the investments. Most MDAs would have a particular set of things that you can and can't invest into, and that might, because it is a really low threshold for tripping over that definition. So probably that final catch-all is probably something that you want to have a look at very carefully before calling yourself independent. But it's a really good question.
yeah. But you know, is there anything prima facie in that structure which rules out the use of the word independent?
Yes, quite possibly. The fact that there is a lot of control around what that MDA would be expected to hold. So that might be what causes that to become unstuck. But yeah, hard to say without seeing the model or the structure, having some time to think about it. But I would have thought, yeah, given the relatively limited nature of MDAs in that sense, that could be problematic. Yeah, but you'd have to think through that.
Yeah.
Does that make
Um,
sense?
yeah. Now, a couple of look as we're sort of nearing our 1 o'clock threshold. A couple of extra questions that have come in. Is there a requirement for an annual fee? Yeah, well, in fact, we might talk about annual fees. Is there a requirement for an annual fee disclosure opt-in required for an MDA? So,
Yes, yes, there is. You can have a look at that. It's in RG 179. So you are required to provide that annual statement in respect of the MDA. It's required to essentially cover the same fee disclosure. You would ultimately end up with the same numbers in terms of those management fees and costs. There's a whole number of other prescriptive requirements in there. You can find a easy to follow guide on that NRG 179 around the 111 mark. I had a look at that one, that very question before.
but
And
that issue of the annual fee disclosure for the MDA itself, that doesn't require an opt-in. It just requires that annual fee statement to be provided.
yes, it
I think
does.
this question's probably driving at the opt-in requirements for advice fees.
Okay. Yeah, we'd have to have a look at that. I think on the MDA side, yeah, on the regulated platform side, there is an exemption if you jump through a couple of hoops for that purpose as well. Yeah, we'd have to have a look at the SOA side
Yeah,
separately.
yeah. My take would be you have to provide the 13-month review of continuing suitability, and so long as the suitability remains, you pass that test, you're not getting an opt-in for the MDA fee as such. You may be getting an opt-in for the advice component. Now, one question here. With regards to the annual opt-in, I think this probably means the annual review. Another guest earlier this week mentioned that this can be done as an ROA, which doesn't need to be signed. So that...
wouldn't that depend on whether primarily there has been a significant change in the personal circumstances of the client?
Yeah. So assuming no change in the client's circumstances, you'd be just doing an ROA. But obviously, if there's a need for change, then you might be in the SOA territory. But
for sure.
Yeah. Clearly, this is now. There was one question here, which is bit more intricate. I'm a bit confused about the fee disclosure layers. If the test is to mimic managed investment scheme disclosure, we take the example of ETF1 investing in ETF2 and other assets. To my understanding, ETF1's PDS will only disclose the MER of ETF1 and won't disclose underlying MERs.
I think that ETF would have a lot of explaining to do, given that they're only allowed to invest in certain things. If you're talking about an active ETF, I guess that's possible, as opposed to a true to form traditional passive ETF. In that example, the fees that would filter up the underlying ETF would be the interposed vehicle. But then you would have that's forgetting about MDAs. Once you put it on the platform, there's the MDA that would go into the platform. There'd be an ETF and another ETF, so there'd be a lot of interposed vehicles there.
Yep. All of this is sounding like a bit of care to make sure the disclosure is correct.
Couldn't agree with you more.
Oh, okay. Sorry. Just back to this sort of annual test. The question doesn't relate to advice fee, just to be clear. So yes, back to the annual fee statement. This is for the questioner who put in the question about the annual fee statement. It said it could be done as an ROA, which didn't need to be signed. Well, the annual fee disclosure is just that. It is just disclosure. It isn't an ROA and it isn't an SOA. It's disclosure. The costs that were incurred by the client. That's a correct understanding, isn't it, Michael?
Yep.
Yeah. Final question here. With RG97 and the MDA regulatory framework continuing to evolve, what do you see as the biggest areas of fee and cost disclosure risk for MDA providers today, particularly where the MDA fee is bundled with portfolio management, admin, and investment costs? So that's a broad-ranging question.
Yeah, that's exactly the problem that I see. I think it needs to be resolved. None of these models are standard. They're all different. There's no real guidance, because all of the extensive guidance is provided on running a managed investment scheme, a super fund, an IDPS, and so forth. There's just nothing there. So the models aren't standard. The disclosure doesn't go into the right level of detail. This is why we are where we are, Toby.
Yes. Well, this is that's a polite way of saying seek legal advice, isn't it, Michael? It's
yes, I would definitely recommend seeking legal advice. This is not one of those areas where you just rely on your favorite robot. So you get AI and you filter your FSG through some model and it makes suggestions. This is not the area to do that in. It's treacherous. It's nasty. MDA disclosure is nasty. Definitely speak to a lawyer about it.
Yeah. But suffice to say that for 25 years, each organisation has taken its advice, formed its view as to what should be in the FSG and the statement of advice and the annual fee disclosure, and tried to make it fit to the service that they offer.
True, Toby, and I have seen it improve. Just a few years ago, a lot of the issuers, you'd find their FSG online, they wouldn't even have the fee disclosure table that you're expected to find, pretty much like what appears in a PDS. The did you know warning box, none of it was there. Most people are doing that now, thankfully. Hopefully they're drilling down into the next level of detail, but I have seen improvements over the last few years for sure.
Yeah. Well, look, Michael, thank you very much for your very informative, wide-ranging discussions of the intricacies of fee disclosure. It's probably one of the least compelling parts of the MDA story. So to those of you who've joined us today, thank you very much for your time. I hope you found it worthwhile. The webinar and the slides are available through IMAP Connect over the next day or so, and then ongoing with attached CPDs. So if you think watching this would benefit one of your colleagues, feel free to refer them to IMAP Connect, available through the IMAP website. Join us tomorrow, where we'll be leaving the intricacies of MDA fee disclosure, and we'll be heading for the sunlit uplands of strategic considerations for managed accounts for MDAs. So, Michael, thank you for your time. To those of you who joined us, thank you for your attendance. We look forward to seeing you tomorrow.
Thanks, Toby. Thanks, everyone.
Thanks.